Let me call, in order to balance this, Jeff Deskovic.
Deskovic, yes.
Could you go on?
Yeah, thank you. My name's Jeffrey Deskovic. I'm the founder and executive director of the Jeffrey Deskovic Foundation for Justice, which works to free wrongfully convicted people as well as prevent wrongful convictions. I'm also an advisory board member of It Can Happen to You. I have a master's degree from John Jay College, so my views are not going to be shaped solely by my own personal experience, but also by my formal as well as informal study. I started my organization as a first-person advocate because I served 16 years in prison in New York. I was wrongfully convicted of a murder and rape, which I did not commit, despite a negative DNA test. The results of this wrongful conviction was that I was in prison from age 17 to 32. Prosecutorial misconduct was a major factor in my wrongful conviction and preservation of same. Firstly, the trial prosecutor, when the DNA test did not match me because I was excluded pre-trial from results from the FBI lab, one day before officially receiving those results from the lab, from the FBI, he rushed off to the grand jury to obtain the indictment so as not to be able to have to present that evidence. In the furtherance of going against the exculpatory DNA test, which should have resulted in the case against me ending right then and there, the prosecutors suborned perjury on the part of the medical examiner, getting the medical examiner to fabricate findings of an autopsy, findings which he had not mentioned when he initially did the autopsy. It took him 6 months to come up with these findings in order to help the prosecutor get around the DNA test result. It enabled the prosecutor basically to argue that the victim, who had already lost her life and had been raped, he trashed her reputation and insinuated that she had been sleeping around, and so therefore it didn't matter that the DNA did not match me because it could have come from one of these consensual sexual episodes. Not only did he argue that against me, but then he named another youth by name that he falsely claimed that had this encounter with the victim. But he made an improper argument in doing that. He never presented a proper evidentiary standard. He didn't have a DNA test result performed on this other youth. He didn't even call him as a witness. He just made the unsupported argument to the jury. When the hair on the body did not match me, again, the prosecutor resorted to an improper argument that he made without first establishing an evidentiary foundation. He claimed that the hairs must have come from the medical examiner and his assistant. I later learned during the discovery process of successful litigation that I brought once I was exonerated, that when the hair expert learned that that was the argument that the prosecutor was going to make, he requested that the prosecutor provide him with the samples, and that prosecutor declined to do so. That was also never turned over to the defense. I want to add that my civil rights lawyers were able to find 3 additional cases in which the same trial prosecutor, George Boland, had worked with this medical examiner, altering results in order to fit prosecution theory. In addition to that, I also, there was prosecutorial, well, let me just add that nothing ever happened to that prosecutor. When I brought successful litigation, although all the parties ultimately settled with me except for the one party that I went to trial with and won a jury verdict on, the case against the prosecutor was dismissed based on prosecutorial immunity. In his footnote, the judge dismissing it said he felt constrained by the law to do so, but that he wasn't dismissing it because he didn't find that I had evidence or that the allegations were not serious. He noted that I could pursue a remedy outside of the courtroom. So when everything finished, I circled back with my civil rights lawyers and I told them that I wanted to file a complaint. I wanted to take the judge up on what he had suggested. And my civil rights lawyers, who had done a spectacular job for me, told me that it would be a waste of time and it would be a waste of money because nothing ever happens. So basically, the prosecutor got away with it. I want to add that 2 weeks before I emerged, suddenly he retired and ran to Florida I guess we're supposed to believe that's a coincidence. So although he's not practicing law now, he still retains a law license, and he could practice law at any point in time in the future. More importantly, nothing ever happened to him, certainly not criminally, not in the courtroom, not civilly, no censure, nothing. I was a victim of prosecutorial misconduct on the post-conviction level. First of all, I had requested further DNA testing twice from then Westchester District Attorney Jeanine Pirro. She rejected my efforts at getting further DNA testing, even though there was a prior Westchester County case, that of Terry Chalmers, in which she consented to exoneration based upon exculpatory DNA test results, stating publicly and defending that exoneration that the DNA test results made it clear that it was the right thing to do. So she knew, her and her office were well aware of DNA implications and its power, and yet she saw fit to deny me twice the testing. On the federal level, her office successfully got the court to dismiss my habeas corpus petition because I was 4 days late. The court clerk gave my lawyer the wrong information regarding filing procedure, and I had an actual innocence argument there based on the pretrial DNA, and they made that argument. Attorneys in that district attorney's office made arguments as spacious as saying that there was overwhelming evidence of guilt, which was laughable if it wasn't such a serious thing, considering the DNA. Ms. Pirro there's nothing to stop her from practicing law. Nothing ever happened to her. My organization.
She's a judge now, isn't she?
She's a judge now, yes.
A fake judge on TV.
A TV judge, yes, but we all, yeah, of course, but we understand what I'm trying to get at, though.
I got you.
In the case of two of the clients of my foundation that we were able to exonerate, Mr. William Lopez, who served 23 and a half years in prison, the federal judge in releasing him stated in his opinion that he referred to there being a deceitful prosecutor. I want to share the tragic news in terms of to bring home the human impact. My friend, my client, he died after a year and a half of freedom. His life basically stolen from him in large part based on prosecutorial misconduct. The other exoneration, that of Mr. William Hawley, which was up by Putnam County DA Tendy's consent, which I want to give him credit for doing. The prior DA, Putnam County DA Levy, offered 3 different times to release Mr. Hawley, but on condition he would have to plead guilty. Just the fact of him making that offer after a conviction had already occurred in an arson case that wasn't actually an arson showed that he knew there was something wrong with that conviction, and yet he insisted on that despicable condition, which Mr. Hawley refused to cave into, and ultimately he was exonerated. There's a lot of studies, from the Innocence Project to the California Innocence Project to the Pew Center, to remarks by Federal Judge Kozinski, to studies from various newspapers and magazines of stellar credibility, that there's a prevalence of prosecutorial misconduct. If the present system was enough, then there would not be a prevalence of prosecutorial misconduct. In all these different wrongful conviction cases, the common denominator is often prosecutorial misconduct. How many prosecutors in the studies that have been done of those cases have been disciplined afterwards? I want to also add that each one of these instances has cost New York State millions of dollars, but more importantly, it devastates the lives of the people affected. My family and the family of many of all the wrongfully convicted people, they were impacted as well, and there was a larger societal cost. The actual perpetrator in many of these cases strikes again. It happened in my case. The actual perpetrator killed the second victim 3.5 years later. There is no deterrent. I don't think that training, I'll wrap up in just a second. I don't think that training and referencing various methods of reversing a wrongful conviction, that's not discipline. While certainly a big part of this, as I see it, my being a supporter of this, is a deterrent, some of it has to be punitive as well. When intentional, clear-cut misconduct happens, training doesn't quite cut it. I don't think you should consider exonerees to be survivors of crimes that were perpetrated against us, and I can't think of any other penal offense where an offender receiving training would be considered to constitute justice. And my last remark will be, and I thank you for having this hearing and entertaining myself and the other panelists, is while there has been a couple of good changes, I mean, the Putnam DA did do the exoneration, and the Bronx DA sitting to my right did have the Richard Rosario case overturned, which I give her a lot of credit for, 13 alibi witnesses. And I want to point out that the indictment is still not dismissed, by the way, even though there's the 13 alibi witnesses. But going past that, while we do have a couple of great changes in the promise of justice within both of those offices, we cannot say that means that there's a prevalence, that's the general attitude, that's pervasive. That's not, you can't overgeneralize that. And I think the biggest reason why you should enact this legislation and have a commission is that there is a denial within the profession of prosecutors that prosecutorial misconduct, that it happens. And so long as there's a denial, that's even more reason to note that, it's not going to end if we keep the status quo as it is. Thank you very much.
Thank you. We have 2